Have you heard the saying you can't sue someone twice for the same thing? That is not just a principle of fairness, it is law under Section 11 of the Civil Procedure Code CPC, known as res judicata. Res judicata is a Latin term meaning a matter already judged. Section 11 CPC says that if a dispute between the same parties on the same issue has already been decided by a competent court, then it cannot be relitigated. In other words, a final judgment by a court on a specific matter between specific people prevents that same matter from being litigated again between those same people or their legal representatives. This principle is based on the idea that people should not be able to harass others with endless lawsuits over the same issue, and that judicial time and resources should not be wasted on duplicate cases. Now let's break down the essentials of Section 11. For res judicata to apply, 3 things must be proved. First, the matter must have been directly and substantially an issue in the earlier suit. Second, it must have been heard and finally decided by the court. And third, the court that decided it must be competent. Additionally, the parties in both suits must be the same or they must be legally represented by the same people. If these conditions are met, then the second suit is automatically barred. However, there is also a need to show that the second suit raises the same issue of law or fact as the first one. If all these conditions match, then the second suit is barred. Let's look at an example to make this clearer. Suppose a sues B over the ownership of a piece of land and loses the case. This means the court has decided that B is the rightful owner of the land. Now, A cannot go and file another case against B, saying that he wants the land back even if he changes his arguments. In this situation, the court will dismiss A's case because the matter has already been decided. This is called no court in Latin, which means the thing has been decided. Now, there are some exceptions to this rule. Res judicata will not apply if the previous case was not decided on its merits, meaning that it was not decided based on the substance of the case, but rather on some technicality. For example, if the earlier court lacked jurisdiction over the matter, or if the parties were not properly before the court, then res judicata would not apply. Also, if new facts or new laws come into existence that change the legal situation, then res judicata would not apply. In other words, if there are significant differences between the two cases, such as a change in facts or law, then the second case may not be barred. For example, in a case in India, a landlord had filed a case against his tenant for unpaid rent. The tenant argued that the landlord had agreed to accept a lower rent, and the landlord had even given a receipt for the lower rent. The landlord denied this and said that the agreement was for the original rent. The court ruled that the landlord was not entitled to more rent, taking into account the receipt and the conduct of the parties. Later, the landlord filed another case against the same tenant for the same period, seeking the original rent amount. The court dismissed the case under Section 11 CPC as the issue was already decided in the previous case. Similarly, in another case, a bank had filed a case against a borrower for not repaying the loan. The borrower argued that the bank had cheated him by not disclosing some documents that showed that he did not have to repay the loan. The court ruled in favor of the borrower. Later, the bank filed another case against the same borrower for the same loan amount. The court dismissed this case too, as the matter was already decided in the previous case. So when can a person file a second case against the same person? Res judicata only applies if the second suit seeks to relitigate the same cause of action, but if the second suit is for a different cause of action, then it is not barred by res judicata. In this situation, the court will consider whether the new facts or new laws require a different decision in the case. If they do, then the second suit will be allowed to proceed. Otherwise, it will be dismissed. In conclusion, Section 11 CPC is an important provision that promotes justice and fairness. It prevents people from harassing others with unnecessary lawsuits and ensures that once a case is decided, it stays decided. It also saves time and resources of the court. However, there are some exceptions to this rule which allow for the filing of a second case if there are new facts or new laws that were not considered in the first case. I hope you found this video informative. If you want me to cover more such topics, let me know in the comment section below. Thanks for watching.